4 words from a police officer can turn a routine traffic stop into a criminal impaired driving investigation before you have finished processing what is happening. You are behind the wheel, hands on the wheel, blue lights filling your mirror, the window comes down, the flashlight hits your face, and the very first sentence out of the officer's mouth is not a question. It is 4 words. I smell alcohol, right there. That is the moment. Whether you had 1 glass of wine with dinner 3 hours ago or nothing at all, it does not matter in the way you think it does. Because the next 60 seconds, the next 3 sentences you say back through that open window decide whether you sleep in your own bed tonight or in a holding cell. And whether 6 months from now, a Crown prosecutor is reading your own words to a judge. 4 words from the officer, 3 sentences from you. That is the whole fight at that window. There are exact words memorized in advance that stop the evidence gathering right there. Words the Canadian Charter of Rights and Freedoms is completely on your side about. Words that keep the evidentiary burden where it belongs. On the officer, on the badge camera that is already recording, on the notes he is typing in the cruiser after you are gone. And here's the thing that should genuinely concern you. People who know those words still lose. They say every single one of them, get the whole invocation right, and then 1 sentence later they hand it all back. 1 sentence after doing everything correctly. I am going to show you the exact words first because you did not come here for a constitutional law lecture. You came here for a script. Then I am going to prove every clause with the actual charter provisions and real Supreme Court of Canada decisions. Then the 4 things the officer says next to try to break you with your exact response to each one. And then the single mistake that voids everything. The one nobody warns you about. The one I have watched happen in court. 99 drivers out of 100. The second that flashlight hits and they hear I smell alcohol, do the same thing. They panic and explain. I only had 1. It was hours ago. I am completely fine. Every one of those sentences is a gift-wrapped statement going directly into the officer's notes and onto the body camera timestamp. The reason people do it is not stupidity. It is what every parent, every driver education class, every well-meaning person in their life has told them. Just be honest. Cooperate. You have nothing to hide. That advice is what puts people in the back of the police vehicle. I spent years working on both sides of the criminal justice system in this country. I have seen how roadside statements close files. I have watched the I only had 1 sentence do more damage than almost anything that comes after it. And I have sat across from people defending themselves against charges that would not exist if they had simply known 3 sentences in advance. Let me show you how it actually works. You are getting the words first, then the proof, then the 4 pushes and your responses, then the mistake that ends it. Here they are. When the officer says, I smell alcohol, you take 1 steady breath, you keep both hands visible on the wheel, and you say word for word, Officer, I am exercising my right to remain silent. I do not consent to any searches. I want to speak to a lawyer before answering any questions. That is it. 3 sentences. Memorize them exactly. Say them out loud right now, wherever you are. Firm, polite, recorded. The tone is not optional. This only works one way. Calm, respectful, direct. Not frightened, not sarcastic, not indignant. You are not arguing with the officer. You are not lecturing him. You are stating 3 things the way you would give someone your address. Because agitation gets written as uncooperative, and uncooperative becomes part of the narrative that follows you. Firm is your ally, rude is theirs. 3 sentences, level voice, hands where they can be seen. That is the complete delivery. But here is what should genuinely concern you. I have watched people say every one of those words correctly and still hand over the case because of one sentence that came after. 1. The mistake that voids everything is coming at the end. First, the proof behind each clause. The moment those lights came on and you pulled over, you were detained within the meaning of Section 9 of the Canadian Charter of Rights and Freedoms, which protects everyone in Canada from arbitrary detention. The Supreme Court of Canada confirmed in R.V. Grant 2009 that a detention occurs when a reasonable person in your position would conclude they had no choice but to comply with the police direction. You pulled over because you understood you had no choice. That is a detention. The charter turned on. Everything you say from that moment is on the record and is available to be used. And a traffic stop has a defined scope. The officer stopped you for a traffic matter, a lane change, a tail light, a rolling stop. That is the mission of the stop. The Criminal Code and the Highway Traffic Act give officers authority to investigate that traffic matter. When the officer says, "I smell alcohol," he is attempting to expand the stop into an impaired driving investigation under sections 320.27 and 320.28 of the Criminal Code, which govern demands for roadside sobriety tests and breath samples. Those demands carry their own legal requirements and thresholds. Every question he asks you after "I smell alcohol" is gathering the evidence he needs to meet those thresholds. Your silence stops feeding that process. Now, let me take the 3 sentences apart because each one is doing a specific job. Officer, I am exercising my right to remain silent. Section 7 of the Charter protects everyone's right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. The common law right to silence, which the Supreme Court of Canada has confirmed, is a principle of fundamental justice under Section 7. Means you are not required to provide the police with a statement that may be used against you. In R.V. Ebert 1990, the Supreme Court confirmed that the right to silence is a fundamental common law right in Canada that the Charter reinforces, and that applies to any person detained by the state. You are detained, the right applies. But here is the critical thing that most people get wrong. In Canada, the right to silence is not a passive right that operates simply because you stay quiet. Pretrial silence without a clear invocation can, in some circumstances, be given evidential significance that you do not want. Saying out loud on a recording, "I am exercising my right to remain silent," makes the invocation unambiguous and on the record. The officer's notes, the body camera, the cruiser camera, the invocation is documented. That documentation is the foundation of every charter argument your lawyer makes later. I do not consent to any searches. Section 8 of the Charter protects everyone from unreasonable search and seizure. The Supreme Court of Canada established in R. v. Collins 1987 and elaborated through a long line of subsequent cases that a warrantless search is presumptively unreasonable and that the burden is on the Crown to establish that the search was reasonable. The single most efficient way the officer can clear that burden is with your consent. Consent makes the reasonableness question disappear before it is ever asked. When the officer leans in and says something like, "Mind if I take a look in the vehicle?" that is not casual conversation. That is consent gathering. Saying yes, or nodding, or stepping aside, or saying, "I have nothing to hide, go ahead," removes the constitutional protection that Section 8 provides. The Supreme Court confirmed in R.V. Borden, 1994, that consent to search is legally meaningful, and that giving it eliminates the need for the officer to justify the search on any other ground. If you say, I do not consent to any searches, then any search that follows must be justified on independent grounds, and those grounds are challengeable in a Section 242 hearing. The Supreme Court's framework in R.V. Grant 2009 gives a court the authority to exclude evidence obtained in violation of the Charter where admitting it would bring the administration of justice into disrepute. The three factors, the seriousness of the state conduct, the impact on charter-protected interests, and society's interest in adjudication on the merits, are weighed by the judge. That hearing is the fight you want to have in a courtroom, not the rights you want to surrender at a car window. I do not consent to any searches is the sentence that keeps the fight in court where it belongs. I want to speak to a lawyer before answering any questions. Section 10B of the Charter is explicit. Everyone has the right on arrest or detention to retain and instruct counsel without delay and to be informed of that right. You are detained. Section 10B applies. The moment you invoke it, the police are required under the Supreme Court's decision in RVs. Bartle, 1994, to hold off on eliciting evidence from you until you have had a reasonable opportunity to consult with counsel. There is a nuance in impaired driving cases specifically that is worth understanding. Under Section 320(271) of the Criminal Code, a peace officer who has a reasonable suspicion that a driver has alcohol in their body can make an approved screening device demand, and that demand carries an immediate compliance obligation. The right to counsel under Section 10B does not automatically suspend the obligation to comply with a roadside screening demand because Parliament has structured the roadside ASD demand as a brief preliminary step. The Supreme Court addressed this tension in R.V. Burnshaw in 1995. However, the qualified nature of the right to counsel in the ASD context does not eliminate it. The officer must still inform you of the right to retain and instruct counsel, and the full right applies at the station when a more formal evidentiary breath test is conducted. What I want to be clear about is this. Invoking your right to counsel out loud, on the record, in the first exchange with the officer is the right move. It puts the invocation on the recording. It documents that you asked, and it creates the foundation for every Section 10B argument your lawyer makes about what happened next, including whether the right was properly respected in the context of any demands that followed. The right to counsel under Section 10B is not something that automatically activates when you are silent. It is something you invoke. Saying, I want to speak to a lawyer before answering any questions does two things simultaneously. It invokes the right, which triggers the corresponding police obligation. And it creates a documented record on the body camera that the right was properly invoked and that any questioning that continued after it was a potential violation of Section 10B. And there is a reason all three sentences come together in one breath, not spread out across the encounter, because every second you wait between them, the officer asks another question, and the human pressure to answer it builds. Say them together at the front, and every constitutional door is closed at the same time. He can push, he will push, but the structure is in place. Now, let me tell you what I smell alcohol actually is, because understanding it changes how you hear it. It is not a diagnosis. It is not a neutral observation he is sharing with you. It is a technique. It is designed to do one thing extraordinarily well. It triggers the Canadian instinct to explain, correct, defend. You hear it, and something in you needs to fix what he just said. I only had one glass. It was at dinner. It has been 3 hours. I am completely sober. Every word of that correction is on the body camera. Every sentence goes into his notes. Congratulations, you just made his case with your own voice. And the officer can lie to you during the investigation. He can say your passenger already told him. He can say he has already got enough to arrest you and is giving you a chance to tell your side. He can bluff about a breathalyzer result that does not exist in RV. Oikel, 2000, the Supreme Court of Canada confirmed that police deception during investigation does not automatically render a confession inadmissible, and that deceptive techniques are a legal part of the investigative toolkit. This does not mean every officer is dishonest. It means that anything designed to pressure you into talking should be treated as a possible play, not as information being shared with you in good faith. The 3 sentences you already have are the only reliable response. Now, the 3 doors your instincts will try to push you through when you hear, I smell alcohol. Each one feels like the exit. Each one is a longer stay. Door 1, you talk your way out of it. I only had one drink. It was hours ago. I passed the test last time. I am completely fine. That is an admission of drinking delivered on body camera during a detention. And if you then agree to let him look in the car to prove you have nothing to hide, you have just surrendered your Section 8 rights voluntarily. Door 1 closes on you. Door 2, you go quiet, you say nothing, and hope he moves on. Silence without a clear invocation in Canada is not the clean protection people assume it is. The Supreme Court in RV Turcotte, 2005, considered the evidentiary use of pre-arrest silence and confirmed that the relationship between silence and the right to silence in Canada is complex and fact-specific. An unambiguous invocation protects you in a way that unexplained silence does not. Silence without the words is not a wall. It is a gap that gets filled with whatever narrative the Crown wants to build around it. Door 2 closes. Door 3, you get indignant. You demand his badge number. You tell him he has no right to ask. You lecture him on the charter. Every version of that, however accurate it is as a legal matter, reads on his notes as agitated, uncooperative, and potentially consistent with impairment. Your attitude becomes part of his grounds. Door 3 closes. Talk, wait, react, all 3 are traps. The 3 sentences you already have are the only door that opens. Let me be straightforward with you about what those 3 sentences actually achieve, because I am not going to oversell what I cannot deliver. Saying those words tonight may not prevent an arrest. If the officer already has sufficient grounds, if he observed your driving, if he can see physical signs consistent with impairment, if a breath demand has already been made, he may be going through the arrest process regardless of what you say. What the 3 sentences do is stop you from making his case easier than it already is. They stop you from handing him a documented admission to layer on top of whatever else he has. And they set up every Section 7, Section 8, and Section 10B argument your lawyer makes in court later. Your win is not at the window. Your win is in a courtroom with a lawyer months from now, in a proceeding where the fight actually belongs. The roadside is where you survive it. The courtroom is where you win it. And being hostile will not save you. I have watched clients invoke the charter perfectly on video and then flip it by getting aggressive, refusing to step out, pulling away. The report reads like a completely different encounter. Resistant, unstable, erratic behavior consistent with impairment. All of it is now evidence he gets to use. Firm and polite is not weakness. Firm and polite is the record you want your lawyer standing behind. Now, the 4 pushes with your exact response to each one. Push 1. He tilts his head and says something like, "If you have got nothing to hide, why not just let me take a quick look?" That is the consent play wearing a friendlier suit. The answer is one clean line. "Officer, I am not saying I have anything to hide. I am saying I do not consent to any searches. Am I being detained or am I free to go?" That question matters. Under RV Grant, you are either being detained with legal justification or you are free to leave. The officer has to pick. He cannot hold you indefinitely on the basis of a smell claim without escalating to a lawful demand under the criminal code. Either he makes that escalation or the stop loses its legal footing. Push 2. He steps back and says, "Step out of the vehicle." Not a request, a direction. Do not argue this one. Under common law authority and the practical reality of a lawful detention confirmed by R.V. Mann 2004, a police officer conducting a lawful investigative detention has the authority to direct your movement within limits. You open the door, you step out slowly, hands visible, and as you do, you say, "Yes, I am complying. I still do not consent to any searches." You followed a lawful direction. You did not consent to a search. Both are on the camera at the same time. Push 3. He wants you to do things. Follow his finger. Stand on one leg. Walk a line. Say the alphabet. These are standard field sobriety tests, or SFSTs. In Canada, SFSTs administered on the roadside exist within a specific legal framework. A peace officer who suspects a driver has alcohol in their body can make a demand under Section 322.7.1 for a sample of breath on an approved screening device. Prior to or alongside that, officers may conduct SFSTs, but whether those are mandatory or voluntary depends on whether a formal demand for them has been made under the criminal code and whether the legal thresholds for making that demand have been established. The critical thing to understand is that under Section 320.15 of the Criminal Code, refusing to comply with a lawful demand for a breath sample is itself a criminal offense with serious consequences, including criminal records, license suspensions, and imprisonment on conviction. Refusal is treated equivalently to a fail. This is not an area where I suggest a blanket policy of refusal. This is an area where the advice you need is specific to the exact demand being made, which is precisely why invoking your right to counsel immediately matters so much. You need to know before you respond to any demand what is being demanded, under what legal authority, and what the consequences of each available response are. The only way to get that clarity in time is to speak to a lawyer. Tollers. So your position when demands are being made is, I would like to speak to a lawyer before responding to any demands or requests. And then you hold that position until a lawyer has been made available to you and you have had a meaningful opportunity to consult. The officer is required to facilitate that right under Section 10B as interpreted in R.V. Bartle. If you are not provided that opportunity before being required to respond, that becomes a Section 10B violation that your lawyer can raise in the proceedings that follow. Push 4. He softens, he gets kind. He says, look, I can see you are a reasonable person. Off the record, just talk to me for a minute and we can probably sort this out tonight. Nothing is off the record. The body camera is running. His notes are running. His memory of everything you say is running. The gentle voice is the same play with a warmer delivery. You say, I respect what you are doing, officer. I am not answering any questions without speaking to a lawyer first. And then you go quiet. Every part of this holds. Unless you make the mistake, here it is. The mistake that voids everything you just memorized is re-engaging after you have invoked, not answering the question about alcohol, answering anything. He waits a moment, the tension sits there, he softens his voice and says something unrelated. Long shift tonight, eh? Your kid's in the back seat? That is a nice jacket. Where did you get it? And you answer, just once, just to be human, just because silence in that pause felt rude. That one answer is a waiver. In R.V. Singh, 2007, the Supreme Court of Canada confirmed that the right to silence can be waived and that police can continue questioning a detained person who has invoked the right to silence, provided that the person is not being coerced and the person re-engages voluntarily. The moment you voluntarily answer a question after invoking, the courts treat that re-engagement as a meaningful choice, not the silence that followed the 3 sentences, the conversation that came after. The invocation does not vanish, but your credibility in asserting it just took a hit, and the question of whether what followed was voluntary becomes a much harder fight. He did not trick you into anything illegal. He waited 6 seconds and asked a human question. And your instinct to be a decent, normal person did the rest. That instinct has served you well your entire life. At a police stop after an invocation, it is the most expensive instinct you carry. Say the 3 sentences. Then stop talking. Not friendly small talk. Not a comment about the weather. Not a question about how long this is going to take. 3 sentences, then silence. One more sentence and you have started reopening the doors you just closed. I have watched clients invoke perfectly on video and then chat normally 30 seconds later, and the Crown walked into court holding that chat like a gift. Do not be that recording. Here is the full sequence in the order you use it. He says, I smell alcohol. You say, officer, I am exercising my right to remain silent. I do not consent to any searches. I want to speak to a lawyer before answering any questions.